calling the next case, which is Christina Zink versus Genesee Intermediate School District and Jan Cox. This is a mini oral argument on the application. Excuse me. 15 minutes per side for argument. Ms. Wasserman, if you would like to reserve any time for rebuttal, you may. We just ask that you keep track of it yourself.
Thank you, Your Honor. Yes. Christine Wasserman, on behalf of the appellant. I would like to reserve 2 minutes for a rebuttal. It is my privilege, my honor to be here today, not just for Christy Zink, the plaintiff appellant in this action, or even the other employees that the chaos that's kind of come to be with regards to employment discrimination, harassment, retaliation, those types of issues that have come about since the Joliet and McGee decisions. I'm also not here today to prove that I am right in my arguments, although I think I am. I'd like to think so. And anybody you ask would say that's pretty important to me. But I think the importance of today and the argument today is to make sure we get it right, because that's been a problem. We haven't gotten it right. The law surrounding constructive discharge and adverse employment action is chaos, for lack of a better word. The decisions since Joliet and McGee have been unpredictable and unreliable, and quite frankly, don't make any sense. So the purpose of today's argument is hopefully to answer the questions concerning constructive discharge and adverse action, as well as the continued feasibility and reliability of Joliet and McGee. Despite having submitted several hundred pages, I think, of briefing, it was through 3 relatively unreferenced cases that I think I finally began to see the light of what is kind of happening with some of the cases historically. The first case is Green versus Brennan, which is a Supreme Court case, and I did reference that in our reply brief in pretty great detail, so I'm not going to go over it too much. But that case involved allegations of discrimination and retaliation culminating in a constructive discharge, which is what is relevant in this case. Justice Sotomayor, her opinion indicates, with claims of either constructive discharge or actual discharge, the standard rule thus yields the same result. The limitation period should not begin to run until after the discharge itself.
Counsel, good morning. I just have a question for you. If you could help me with this, what were the specific things that the district did in retaliation? Like, if you could just be specific about what it was that the district did in retaliation.
So, to be honest, that never even really came into the question. We never briefed it, either in the trial court or in the Court of Appeals. What the district did and didn't do, ironically, is they created a work environment where every single time Ms. Zink did something, they gaslit her. It was, she would have a conversation with her supervisor, Ms. Cox. Ms. Cox would turn around and talk to the Deputy Director of Special Education and say something else. Then the Deputy Director of Special Education would impose a new rule for Ms. Zink. And it went on and on. There was a transfer that they put into motion, taking her from her special education course or position and transferring her to a PE class, a gym class, that she was barely qualified for, even though others had applied for it. There was a mediation agreement. I mean, the district and the union spent thousands of dollars on a mediation agreement.
So
And-
the point is, if, assuming that we agree with you that her claim accrued at the time of the discharge, that you would still be under an obligation to prove, either to a jury or in opposition to a motion for summary under C10, that in fact that conduct was sufficient to constitute a constructive discharge. Because not every conduct by the employer obviously would be that. So that question, understandably, because we're not, I mean, we're sort of assuming for the sake of argument that you could prove a constructive discharge. The question is did it accrue at that point, or did it accrue earlier when any of this conduct allegedly occurred?
Absolutely correct. The fact that we prevail on this issue today doesn't mean that Ms. Zink wins. It simply means that her claim goes forward, and then we get into the basis for what she claims was her constructive discharge. And the law's clear. It's an objective person standard. You have to show and establish through admissible facts that the work environment became so intolerable that she felt and a reasonable person in her position would feel compelled to resign.
Counselor, how do you deal with our prior case law that says a constructive discharge isn't an independent cause of action? It's a defense to an assertion that someone voluntarily quit. How do you square that with your assertions?
So I don't know how or why that type of decision or language came to be, because Champion versus Nationwide set forth the law with regard to constructive discharge long time ago. And it's well established that the law does not differentiate between employees who are actually discharged and those who are constructively discharged. In other words, once individuals establish that they have been constructively discharged, they're treated as if the employer had fired them. The discharge is imputed, that knowledge, that action is imputed to the employer. That's Champion. And that's been a consistent ruling in our jurisprudence for quite a while. And then you have these outlier cases that they really don't fit in with that analysis.
And the alleged violation that you've pled under the WPA is a discharge, is that correct?
Yes, it's a constructive discharge.
Counsel, I want to just get to some of the district's arguments. One of the things I think that they argue is that by sort of allowing a constructive discharge action to be framed the way you want it under the WPA, the plaintiff could, sort of the tardy plaintiff rule, they could wait, your client could have waited 5 years and now, get the benefit of a very short 90-day statute of limitations that the Whistleblower Protections Act have. Could you respond to that argument? Why are they wrong?
They're wrong because the constructive discharge analysis has the built-in reasonable person, objective reasonable person standard. It has to go before the judge, as Justice Kavanaugh mentioned. It goes before the court, even though it tends to be a jury question, it does go before the judge for a reasonableness, an objective reasonableness consideration.
So you would agree that is something at like a C10 stage of the litigation under a motion under C10, that is something that, depending on the facts, a judge might be able to consider?
Yeah, I don't believe there's even a might attached to it, Justice Welch. I think, without a doubt, if somebody comes in, especially on a whistleblower case, so you have an abbreviated statute of limitations, if a plaintiff or employee comes in and says that they waited 2 years, 3 years, a year even, to file a whistleblower case, I believe it's absolutely within the purview of the trial court to dismiss that on a C10.
Right, I think you would agree that sort of the standard for a constructive discharge, it's fairly high. A plaintiff has a big burden to sort of prove constructive discharge.
It is, but it isn't. In the case that that I would, it is, generally it is. There has to be some significance to it. Green versus US talks about it, the constructive discharge, and it talks about how it depends on the particular scenario. So, you know, changing somebody's schedule isn't normally considered, you know, an adverse employment action for a normal person. But if you're a single mom with 2 school-age kids that doesn't have any family, having your schedule changed in a manner that makes it impossible for you to come to work can, in fact, be a factor in creating a constructive discharge. That's what the Green versus Brennan case talks about. But there's also a case that Justice Zahar was involved in, the Coleman case, where the only adverse action that led to the constructive discharge was a reduction in pay from $10 to $7. And that was deemed sufficient to create a fact question as to a constructive discharge. And in that case, I would mention it's also a case that is inconsistent with Joliet in that it says the statute of limitations doesn't begin until the harm occurs to the plaintiff. So Joliet says the harm occurs when the defendant acts, the last defendant wrongful act. But Coleman says that's not the case. It's when the harm occurs to the plaintiff, specifically that it is not the defendant's wrongful act. Trenadue is another case that I cited. I think I said it correctly. That case, and this is where I'm talking about the chaos and the confusion that comes from that. But Trenadue is a wrongful discharge case that specifically indicates and does the same analysis that Joliet did. Okay, this is the same justices. It's 1 year after Joliet. The very same statutes are being analyzed for the accrual date. And in Trenadue, there was summary disposition, and it went in front of the Supreme Court, and they held that specifically state regarding determining the date a claim accrues. This is consistent with MCL 600, which is the accrual date for discrimination claims. At the time, the wrong upon which the claim is based. We have not surprisingly given its clarity so held. And then it
Can I
indicates-
ask you, is it, and we asked whether or not, or the question is posed of whether or not both Joliet and McGee would need to be overruled for you to be successful. Would McGee, in fact, need to be overruled, or is it distinguishable because it's not a WPA claim, and therefore the language of WPA is different from the CRA?
Taking that position, Justice Kavanaugh, Joliet doesn't have to be overruled either, because that wasn't a WPA claim. They didn't discuss WPA claims in Joliet or McGee. Had nothing to do with.
But Joliet specifically overruled Jacobson.
I don't understand how, but yeah, oh, I am so sorry.
That's okay. It's for your rebuttal time, I'm sure.
thought
Which you have about 1:40.
Yeah, and I actually
Yeah.
just had one more quick question. I'm going to
Yeah.
try to make sure you can save a minute.
Okay.
Can you respond to counsel's claim that if we agree with you, it's really just a dressed-up hostile work environment claim? Why are they incorrect on that?
Because it's, I mean, I guess if, it could be a hostile work environment claim. I mean, it culminates into a constructive discharge. So certainly, her environment is hostile. The lack of remedial action by the district creates additional hostility. That's why, in part why Joliet's so confusing and doesn't fit, because it's not just defendant acts. It's also their failure to act in remedying. And so I think there could be some overlap into a hostile work environment, but in reality, it's a whistleblower claim. And the fact that it ultimately results in a constructive discharge, I don't believe brings it under the purview of some other type of claim like hostile work environment.
Okay, great. We've got 25 seconds on the clock.
25 seconds.
Thank you.
Thank you.
Good morning, Your Honors. Ken Chappie appearing on behalf of the defendants. The plaintiff contends that she should be able to unilaterally control when the statute of limitations on a claim accrues. That's just plain wrong. Her rule that the statute of limitations begins to accrue for a constructive discharge claim when the employee decides to resign, whenever that may be, is wrong for multiple reasons. It's contrary to the plain language of the Whistleblower Protection Act, which specifically regulates when an employer acts, not when an employee reacts. It effectively eliminates the statute of limitations for constructive discharge claims. The claim can be brought in perpetuity, and it is incompatible with this court's holdings that, one, constructive discharge is not an independent cause of action. It relies on an underlying claim. And two, the longstanding rule that the statute of limitations begins to run when the elements of a cause of action are present, not when the full measure of damages are known. Now, according to the plain language of the statute, the right rule is that the statute of limitations begins to accrue and the claim begins to run when the employer acts last, the last act of discrimination or retaliation by the employer. It's an easy, bright line rule. And the proper treatment of constructive discharge claims, considering the history of Michigan Supreme Court cases and appellate cases, and even the Green versus Brennan case that plaintiff counsel referred to, is that constructive discharge is nothing more than a damages enhancer. It allows a plaintiff who resigns to assert the defense, I didn't voluntarily resign, so I can receive the same damages, back pay, as someone who actually was terminated. I'm going to start with the statutory interpretation. The language is pretty clear. It's the same language actually that's in the Elliott-Larsen Act. An employer shall not discharge. That's how it starts. That language is in both statutes. So that is the act that triggers the accrual of a claim. When an employer takes an act that is inconsistent with the statute. In this case, she's claiming that otherwise discriminated against, I assume, by creating a hostile work environment. There's no ambiguity.
So how would you address, she says that she's bringing a claim that says she was discharged.
Well, she's not discharged, she's constructively discharged, and that's an equitable doctrine, and there's no room in statutory interpretation for equity to apply when there's plain language in a statute.
What about our case law that says that once established, and this gets to your other point that you know, the argument that she gets to decide when her claim accrues is only if she's in fact successful in objectively proving a constructive discharge.
Correct.
But what about our case law that says once it's established, we treat a constructive discharge just as it is the action of the employer?
Sure, Your Honor, there's two parts to that. Once it's established, and that you have to prove the underlying claim that can support a constructive discharge claim. In this case, it would be a hostile work environment. And once it's established, my argument is that you treat, if it's proven that she's constructively discharged, that allows her to obtain back pay damages. It's a damages enhancer only. It doesn't establish a cause of action because the law in Michigan, since at least 1994 with the Vax versus Perry drugs case that has been adopted by this court over and over again, is that that constructive discharge is not an independent cause of action. It relies on an underlying claim such as a hostile environment claim. And her rule leads to a legal, illogical result that if you constructively discharge 4 years after the last employer act, and that constructive discharge is reliant on an underlying hostile environment claim, you may not be able to prove the underlying hostile environment claim because it's barred by the statute of limitations. There may not be an employer act within 3 years of the date that the employee had decided to resign.
How would she, in that scenario, how would she prove a constructive discharge if she waited 4 years afterwards? Doesn't that go to the question of how intolerable could it have been because you lasted 4 years?
That's true. That is a valid point, and it would be a point that is brought up in cases that where that happens. But here's the problem with that approach, just making it a question of fact. It's still prejudice as a defendant. It is not a small, inconsequential thing that they have to go through discovery, 9 months of costs of depositions and discovery, and make it a question that's decided on a motion a year after a lawsuit is filed under C-10. It should be something that could be decided as a matter of law up front, like a claim that someone was involuntarily terminated. Now, if the plaintiff's claim is accepted, that she can control when the statute of limitations begins to accrue by the time she decides to resign, if it's 5 years down the road. Consider what happens with someone who's involuntarily terminated under the Whistleblower Protection Act. The supervisor says to that employee, I don't like that you called me out for embezzling funds. I'm terminating you right now. That person may not have a paycheck then at that moment or benefits to support their family. They're stuck with a 90-day statute of limitations. Now the employer says, that supervisor says to the employee, I don't like that you called me out for embezzling funds. I'm transferring you to a different department. There's no loss of pay, nothing like that. It is a violation of the Whistleblower Protection Act because it says in there shall not transfer as one of the things that is a violation of the act. But she may say, that employee may say, well, that's causing hostility to me. It's an intolerable situation. 3 years down the road, that person resigns, all the while collecting a paycheck. Why should that person have the benefit of a tolling statute of limitations when there's no real harm to that person and they know about the transfer at the time it occurred? There's no discovery rule issue there.
Is there, I'm wondering, is there any scenario in which there could be a constructive discharge under the WPA without running, in your opinion?
I think the only situation where there could be a constructive discharge under the WPA where it would fall within the statute of limitations is most likely going to be under, Radke suggests that there could be a single incident of hostility that is so severe that someone, can form a hostile environment claim on it. If there's a situation where someone is, I guess the example, have their pay cut in half, and someone says, well, I can't live off this, I have to go find a new job right now, then that'd be a situation where there is an adverse act that's occurring within the 90-day statute of limitations where they may be forced to resign to go find new employment. That could be a scenario.
But they would, would they have to resign the same day for it all to count? Or what if
No,
they're
I'm
like
not saying-
trying to work it out? They're trying to work with their employer to work it out, like maybe it's an egregious sexual assault or something, and they complain about it, hoping that the alleged assaulter gets transferred or terminated or whatever, and they don't. And so they stick it out, hoping that things will improve. I'm assuming you would say, well, sue under Elliott Larson, don't sue under the Whistleblower Protection Act. Is that?
I would, because case law is that, yeah, that would be an Elliott Larson case. It wouldn't necessarily be a Whistleblower Protection Act case. And you could still sue based on the last employer act. I think even in that scenario, when there's back and forth going on between an employee and an employer about what to do, and the employer says, well, I'm not going to do anything about it, that you're going to have to put up with those circumstances, there is an act on that day. It's an affirmative statement that we're not going to do anything, which is distinguishable from just the failure to act and ignore something.
What if they tell you they're going to act and then 120 days passes and they don't?
Well, it's a failure, that's a failure to act. You're not acting. It's the last act occurs. If you're not following up, if there's no dialogue, there's no conversation, there's no act occurring. I think a reasonable person under those circumstances would realize after 30 days of nothing going on that.
Well, and I guess that's sort of my point. Is that really an accrual question, or is that a question of constructive discharge? Whether the facts warrant a constructive discharge. meaning, does it fit the statutory definition of a discharge to sustain a claim? I mean, I get, like, in any scenario, right, all of these cases are going to be highly fact-specific. I'm struggling with seeing it as an accrual question as opposed to whether or not there actually is, in fact, a discharge.
Well, I would agree. There is an issue of whether that even constitutes a discharge. But the issue, though, we have then is, well, when does the claim accrue then? In the bright line rule that makes it easy to solve, when can you bring this lawsuit? It would be based on the last act of the employer.
Why isn't the date of the discharge a bright line rule too? I mean, it may fail because you can't show that that was objectively reasonable, but that's also a bright line, right? That's the completion of what she claims her claim is.
Sure, it could be 25 years down the road.
Sure,
at the
and
same
then
time.
she would probably lose
She
on
would
a
probably
constructive
lose
discharge.
After the defendant has to expend $100,000 in attorney's fees costs and going through depositions and discovery, and there wouldn't be an opportunity to get out on a motion right off the bat that says this violates the statute of limitations. There's going to be all sorts of problems with that. It does violence to the policy behind statute of limitations to preserve evidence, make sure witnesses are available, witness memories are preserved, that documents are maintained. There is a case that you could go on for literally ever. I mean, an act could happen when an employee's in their 20s, and then they could bring suit in their 60s.
So Counselor, we have, to the extent that it's persuasive, obviously it's a different statute and ELCA is a different statute, but looking at Green had a circuit split on this question at the time it was decided. And the court rejected the argument you're making. The court decided that in that context, under that statute, that was a cleaner rule and a clearer rule to go from the resignation. So why shouldn't we find Green persuasive?
Well, the regulation in Green was much different than the statutes that we have here. The statutes we have here have modifying language in it. It says an employer shall not. It's based on employer acts, specifically in the statute. The regulation at issue in Green was not that clear. It stated that when a discriminatory matter occurred, and it was determined to be ambiguous by the court. And not only that, Green then later states that it infers very distinctly that I have the case sitting right there, but it says that constructive discharge cause of action in there, that it is a distinct claim from actual termination. So it infers strongly that a constructive discharge is a cause of action under federal law, whereas here it's the opposite. We have a clear, bright line statute that specifically states when the act is violated, and second, it's been the law and hasn't been contested that constructive discharge isn't an independent cause of action. It relies on proving an underlying claim. Now,
The discharge under the WPA is a claim, correct?
I'm sorry, a
Discharge.
discharge, yes, by the employer. Employer shall not discharge. Yes, I would agree with that. So what we have a problem with then is we have an illogical conclusion then if they cannot prove the underlying hostile environment claim because the acts all fall outside of the statute of limitations. Say, Justice Kavanaugh, that maybe that might be a scenario where if the acts all fall outside of the statute of limitations that support the underlying hostile environment claim, you could file an immediate motion based on the statute of limitations. But then what does that do to the constructive discharge claim? There isn't a claim left, and that's what would happen in this case. If that were to happen, because there is not a single employer act that is alleged to have occurred within the 90-day statute of limitations, the last thing that's alleged to have occurred, I believe, was the positive overall performance evaluation for the plaintiff, which is hardly the type of intolerable conditions for a work environment, but nonetheless, I think that may be the last act. It was either that or allowing her to go on leave. But there is no employer act within that 90-day statute of limitations. And if you look at Jacobson even, Jacobson says that what is actionable is what occurred on October 21st, 1989, which is the one day on the 90-day statute of limitations. It wasn't any acts occurring before that date, just what occurred on that date that she decided to resign. There are no acts that you can connect to that decision in this case because we have no continuing violations doctrine under GARD. So in order to prove plaintiff's claim and have her rule installed, you have to undo a lot of case law in the state of Michigan. You'd have to undo Connolly, which for 50 years has determined when the statute of limitations begins to accrue on a claim. You'd have to undo guard, which determines, states that continuing violations doctrine doesn't apply. I think Champion more favors what our position is than it does the plaintiff's position. It's stated there that the constructive discharge, the decision to terminate, effectively was the employer's decision to rape the employee, not the decision by the employee to leave, because under a reasonable person standard, you would be presumed to quit under those circumstances. That takes the plaintiff's decision to resign completely out of the equation. That's even stated in the Joliet dissenting opinion, too. It more relates to the reasonable person. What would a reasonable person do under those circumstances, as opposed to when subjectively a plaintiff decides to resign their employment?
Why is that more workable? Like here, when should she have resigned? Or when do you think the claim accrued here?
When did the claim accrue here?
Yes.
Well, she makes her claim, first of all, I don't think there's a hostile environment claim
Okay,
here.
understood. Okay, so that's fair. That's fair. So maybe harder for you to pick a moment, but
I can say in generalities, the last time the employer did something that she felt was harassing towards her.
what if it's like a buildup? So it's the straw that broke the camel's back, and so we're supposed to like assess whether it was reasonable at that moment? I mean, obviously an example of sexual assault, it might take someone a little while to realize, oh my gosh, I've got to get out of here.
Sure. But yeah, if you have the moment, the straw that breaks the camel's back type of scenario, it's still based on an employer's act. It's not based on sitting around and thinking about, well, what's going on here? No one's talking to me. No one's harassing me at this point in time. You have an end date of when you were last harassed. Here, I mean, plaintiff counsel talked about the transfer. That happened the transfer she was told about was 1.5 years earlier, and it was only necessitated by COVID, and it never happened because they ended up getting a qualified applicant coming back to the applicant pool. But yeah, I think under those circumstances, the bright line rule would be really easy to say, well, the employer last did this. The employer called me names on this date. The employer threw a coffee cup at the wall and made me feel threatened on this day. I can tie my claim to that moment and say, all these things happened culminating up to that point where I was done. I couldn't do it anymore. Constructive discharge is supposed to be the worst case hostile environment claim. I mean, that's the case law from federal court and this court in courts of appeals interpreting what a constructive discharge really is. If you have to really think about what's so bad about my environment, it takes time to say, well, geez, I don't know if I can continue this anymore. It's not really reaching that breaking point. It's not so intolerable that I have to walk out immediately, like the sexual assault situation. I think that's a pretty easy situation. Someone getting physically aggressive with you, I think, would be a pretty easy situation to say this is a constructive discharge. I don't think that, petty workplace disagreements, it's never been the law that even violates hostile environment principles. You have to have some kind of egregious conduct, and it has to be pretty obvious. Otherwise, you don't even have a constructive discharge. I believe I've gone over my time. So,
Thank you.
thank you.
You have 24 seconds,
Thank you.
unless somebody asks your question.
I disagree. Obviously, I disagree. So to have a WPA claim, you need to have a materially adverse employment action. That is defined by multiple cases. It's not, they called me names. All right? So that a defendant act can't create a WPA unless it's a materially adverse employment action. It can't. So this idea that just because the defendant called somebody names, Ms. Zink could run and file a lawsuit for retaliation under the WPA, that's absurd. She can't. She never had a cause of action in this case if you buy the defendant's argument. Even the Court of Appeals indicated if she had a cause of action at all, it accrued on defendant's last act. But as I said, Trinidad talks about the wrong for statute of limitation purposes. The wrong is done when the plaintiff is harmed. rather than when the defendant acted. The claim accrues when the harm is done. That is a constructive discharge. Champion does not in any way support their claim. Conley does not in any way support their claim. Conley says you have to have an accrual of a cause of action. You have to permit a plaintiff to have a cause of action before you can say that it's untimely under the statute of limitations. You
Thank
just
you.
have to.
Your time has expired. Thank you for your
Thank
argument.
you.
The case will be submitted.